Senator Lee.
Thank you, Justice Scalia and Justice Breyer, for joining us. It's an honor to have you here today. Justice Scalia, I wanted to follow up on some things you had said in your opening statement, along the lines that it is and properly should be a difficult, cumbersome, time-consuming process in our constitutional republic to enact legislation. I think the courts can and should play a significant role in ensuring that that's always the case. The court certainly has played a role in the past in cases like INS v. Chatham, in which the court has stepped in and said, you know, notwithstanding the fact that you, Congress, may have found something that makes the process of legislating easier or perhaps even more efficient or collegial, you haven't dotted your I's and crossed your T's in the same way that we contemplated under Article I, Section 7, Clause 2, requiring bicameral passage and then presentment. And so this provision is invalid. Let me ask you the question, is there also a role for the courts? Can you foresee a role for the courts in other situations in which Congress, some future hypothetical Congress, might do something different that would prove easier and more efficient and more collegial, but perhaps in a way that's antithetical to the Constitution? For instance, let's suppose that Congress, when legislating on the delicate and pressing issue of maintaining the proper records in the dog breeding industry. Since we're talking about federal legislation, these would of course be dogs either moving in commerce or taking advantage of some channel or instrumentality of interstate commerce. But a law in which Congress just passes a law saying we're outsourcing, we're delegating the authority to regulate dog breeding and record keeping for purebred dogs to the Board of Directors of the American Kennel Club. That passes both houses of Congress. It goes to the President. It's signed into law. And we then have outsourced the regulation of this practice to the American Kennel Club. Is that a situation in which you can anticipate the court might step in?
Well, I would step in. I don't know if the court would. I was the dissenting vote in the first case involving. I hate to mention this with my friend Stephen here, since he was on the Sentencing Commission. I thought when Congress created a Sentencing Commission to decide how many years everybody should spend in jail, because presumably Congress didn't have the time to figure it out for themselves and just left it to this commission to do it. I didn't think that that was constitutional, so I am sure I wouldn't like your dog breeding body either. But I can't speak for the court. I don't know what the court would allow.
But for you personally, looking at it, notwithstanding the fact that it's more efficient, notwithstanding the fact that you do have bicameral passage and you have presentment of this hypothetical law, the problem is that you have delegated the lawmaking power.
Exactly.
Exactly. You have to be careful, because John Jay, I just read this in John Stevens' book. It's pretty good. The first chapter, he says, John Jay, first Chief Justice. And George Washington went to him and said, I have a lot of questions here. I don't want to do anything unconstitutional. Here are a bunch of them. Will you answer them? And John Jay said, no advisory opinions. He said, we're not giving any advice. But the real reason, of course, is he didn't know the answer. So he doesn't want to give it.
And he was right. And he was right. And his tenure on the court proved to be short-lived in any event.
Now, the situation you pose is quite different, of course, from your leaving it to an agency.
So how is it different then? How do those differ?
Well, because when you leave it to an agency, you are giving it to the executive. The executive can make rules. You can't run an executive operation without making rules. The doors open at 8 o'clock. If you're the Interior Department, you can't have fires on public land. You can graze private cattle on. It's up to the agency to make rules. But there is an obstacle that discourages you from giving too much power to the executive agency, because you are increasing the power of the president. You're a competitor, the president. The separation of powers with different branches competing. And there is no such disincentive when you leave it to this private group that you're talking about. That is just a pure delegation of legislative power. You are not authorizing an executive to act like an executive, but you are delegating legislative power to a group that has no executive responsibilities.
So the difference, you would insist, is based on the fact that this is an executive branch agency which, at least in theory, is subject to the disposition, subject to the control, to the direction of the chief executive.
I think that's right, and I am what can I, you're talking about the doctrine of unconstitutional delegation of legislative authority, which is a bad name for it because there is no such thing as a constitutional delegation of legislative authority. You cannot delegate legislative authority. Now, when you give rulemaking to an agency, how far can you go? Can Congress just get together and say, the president can do anything he wants and adjourn? Of course not. That has to be unconstitutional. But is it up to the courts to decide where the line is drawn between giving enough authority to the chief executive and too much authority? It is simply a non-justiciable question, and I, for one, would not let the courts apply the doctrine of unconstitutional delegation, where the delegation is to the executive.
As long as it's to the executive branch agency, then even if
I wouldn't get into it. Some of my colleagues would, I suppose.
Even in the extreme situation where we passed a law saying, for example, we shall have good law, the power to make good law is hereby delegated to the Department of Good Law, which is hereby created.
I'd do that one, all right. But that's not going to happen. I'm talking about any real situation. I can't imagine my sticking my toe in that water.
Okay, okay. And Justice Breyer, I had a question for you. I've really enjoyed reading parts of your new book, Making Our Democracy Work. It's very well written and fascinating. I think it's good reading for any law student or lawyer or American who wants to learn more about the system. You suggest in your book, at page 126, that there's rarely an easy answer to the question of what level of government should be primarily responsible for helping to resolve the problems that potentially call for legislation, and that the question usually turns on empirical information such that facts help determine the answers. Yeah. You go on to explain in pages 125 and 126 that very often this means that the courts ought to step aside and, if I'm understanding you correctly, have Congress more or less decide the precise contours of the boundaries of federalism. Is that, am I understanding the book correctly in that regard?
Yes, that's right. I think it's, because you go to abstract, but it's just, if you start talking abstractly, the trouble is you can characterize any individual situation usually in 15 different ways at different levels of abstraction, and depending on how you characterize it, it'll seem appropriate for a federal answer, or it'll seem appropriate for a state answer, a local answer. Is it a police department problem? You say, well, it's arresting somebody. Yeah, but you're arresting them for having guns. And, well, it's a state problem. Well, but the guns are torpedoes and they're only made internationally. And so that's so complicated and difficult that it's hard for the courts to find a general principle there. That's my point there, and that's why.
So if that's the case, and if it's also the case that under, as we read in Federalist number 45, the powers of the federal government are few and defined, whereas those of the states are numerous and indefinite, then members of Congress should read the Constitution, decide what those contours are, and restrain ourselves rather than waiting for the courts to step in and say, no, you've overstepped the bounds.
My point that I was making there is you are elected by officials in a state, and so you will make such judgments on such matters as you believe are appropriate in light of how people, partly how they feel and partly what you're trying to represent, but that it is a lot of that is your decision.
Right.
Senator, of course you have to make those constitutional decisions. You take the very same oath that I take. The only reason I can look at a federal statute and say I have to disregard this because it does not comport with the Constitution, the only reason is that I've taken an oath to uphold the Constitution. You take the same oath. So, and we give deference to legislation on the assumption that the members of the Senate and of the House have tried to be faithful to their oath. And if indeed they're not even looking at or even thinking about the constitutionality of it, that presumption should not exist. So yes, of course you.
So in that respect and to that degree, our oath to uphold the Constitution, our commitment not to overstep the bounds of federalism, means more than simply doing that which NLRB versus Jones and Laughlin Steel or Wickard v. Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said, but we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them. Where your law does not comport with the Constitution, it seems to be a law but really isn't, and so we ignore it and apply the rest of the law, the statute notwithstanding, as one of our early cases put it. But it's really, you have the first cut and the most important cut.
Thank you. Thank you, Mr. Chairman.